Good morning, friends. All of you know that on March 24th of this year, the Prime Minister of India came to the media, before the electronic media, and requested the people to observe the shutdown, 3 weeks shutdown. So it may be effective up to April 14th. So now let us discuss the legal and constitutional aspects of the shutdown, whether it is legally or constitutionally valid or not. This is the main topic for discussion, because since we are all lawyers, we have to know the legal position, right? You are well aware that the Constitution of India gives the right to life, but the said right to life without right to livelihood, which has been suspended by the government with the provision of Disaster Management Act. And normally it is creating trouble. No doubt many people are willing or volunteering to the enforcement of the lockdown. Please remember, the government of India is depending on two major sections, major acts, literally we can say. So number one is the Epidemic Diseases Act 1897, and the second one is Disaster Management Act 2005, right? Prior to that, the government of India and also the state governments, they are trying to enforce the provisions of section 144 CRPC, that is assembly of 5 or more persons at one place. It is prohibited. Section 144 CRPC gives a clear-cut prohibition that more than 5 people should not assemble at any place. You are well aware that the main crux of the coronavirus or COVID-19 is the social distancing. So the social distancing is possible only if one is distant to the other. Please remember, the virus does not itself travel. The people move it. Therefore, if you stick down to your houses, definitely the virus will wither away. Right. Now coming to the constitutional point, you are well aware that Constitution is the mother of all laws. So, according to Article 356 of the Constitution, so the emergency can be imposed basing on the 3 grounds. Number 1, in the time of war. Number 3, external aggression. Number 3, external aggression. Number 3, internal disturbance. Of course, it was amended after Indira Gandhi's regime, that emergency provision. Previously it was different thing. Anyway, so internal deference is the one of the criteria where they can go for the so-called emergency. Of course, some people have started they are started saying that Article 360, that is financial emergency, may also be imposed in India. It's a different aspect anyway. So coming to the emergency provisions, Article 356 tells about the 3 conditions on which the emergency can be declared. Of course, the government did not declare any emergency. They are dependent on majorly on the Disaster Management Act as well as the Epidemic Diseases Act. Of course, you are knowing that Epidemic Diseases Act was imposed in 1897. That is before the framing of the Constitution of India. So, Article 13 of the Constitution of India says that whatever rules, whatever laws which are repugnant to the Constitution, definitely they will wither away. If they are in consonance with the present law, they will stay back. Of course, we have to thank the law officer or some other man who has actually stated about the existence of the so-called Epidemic Diseases Act 1897. So, Article 13 says, if they are in consonance with our acts, definitely they will be accepted, and it is one such act. Otherwise, doctrine of waiver, doctrine of severability, or doctrine of prospective overruling, all these things you know, right? Coming to the Epidemic Diseases Act, it is a very simple act. Of course, it is an administrative act passed by the colonial rulers, where there is no other go except, right, it has given enormous powers for the central government to make any rules, regulations, to declare certain disease as endemic or epidemic, all these things. And if anybody, of course it is a small act containing only 4 sections, and section 3 is the penal section. So according to this, if anybody violates any order given by the public authority, he is liable for punishment under section 188 of the IPC. Right? Previously, before the national lockdown, then our government, state government, they used the sections of 188 IPC, section 269, spreading of infectious diseases, 269 IPC, and also 270 IPC. Now comes the Disaster Management Act, which is the most important act today. For that also, before that, I want to tell you about articles 256 and 257. Article 256 says the center can execute its powers on the state also. At times there are occasions where the central should state that their act should be followed. And it is also clearly stated in 257 that the states should implement the acts in a manner that does not impede or prejudice the center. This is what section 257 of the Constitution of India says. So actually this corona pandemic, it is qualified, it should be qualified as internal disturbance. Of course the government is taking measures, they are enforcing the provisions of the Disaster Management Act 2005. Right? This is, of course, very good act. And before telling about the act, I have seen an incident where the sub-collector in Kerala state, she wanted to keep the materials when there was a natural calamity in Kerala about 2 years back. She wanted to deposit the materials in the Bar Association Hall, for which the Bar Association refused, and using the provisions of Disaster Management Act, she kept the so-called materials inside the Bar Association. Normally, we don't give in our room to others, but we had to give because of the provision of this act. So it is such a, of course, such a good act. Normally, it is for the rehabilitation purpose. So normally 3-tier system is there. Section 11A of the Act tells about the 3-tier system. Normally there will be national level, state level and district level. So they will formulate the so-called disaster management program. Then section 19 gives enormous powers to the state to lay down the guidelines for providing the standards of relief. Which type of relief? So the government of Andhra Pradesh, they stated that they are going to give 5 kgs of rice extra or 3 months of ration in advance, and the central government also likely to give some 1,000 rupees or 1,500 rupees to the Jan Dhan accounts, all these things. This is what section 19 says. And regarding the power to give directions, section 22, I think section 22 clause 2 provides that the state authority can give directions to all the other government departments also, and they have to follow the guidelines. And section 34 and 24 to the state and 34 to the center. Sorry, section 24 to the state and section 34 to the district. That is, they will form the executive committees. To forming executive committees actually to control and restrict the movement of the vehicular traffic or movement of vehicles, movement of the people from one area to the other. So this is most important. Now, very recently it happened in Hyderabad. So the state of Hyderabad, they have given permission, they have given NOC to the students of different hostels to get back to their native state, that is Andhra Pradesh. But they were stopped at the border and they were not allowed. This is the section 24 and 34. According to section 24, the state or the district, they can stop people, they can regulate or they can restrict the movement of vehicular traffic or movement of people So please remember, the state can give directions for rescue, evacuation and relief measures. The main purpose of the Disaster Management Act of this only. So now here, as per the provisions of section 24 and 34, now the state as well as the district, they can restrict the movement of the vehicles as well as the movement of the people. That is what they are using now. Right, then now PM Cares, the Prime Minister of India, he has given a call to all the philanthropists, all the people to give donations freely, to give liberally. So according to section 47 empowers the center to constitute a national disaster mitigation fund. Right. Suppose now coming back to the violations. Normally you may be hearing that the central forces, they are coming to Hyderabad, army is coming to the force. Yes, Article 257 clause 2 of the Constitution says that the center on the request of the state can send the additional forces like paramilitary and also military to aid the state in the implementation of the so-called restrictive programs. Now, penal sections. You are all well aware, section 51 is more important. Section 51 says that if anybody obstructs the public authority or any government officer in the discharge of his official duty, he is liable for punishment for 1 year or 2 years depending on the circumstances. Normally 1 year. And there is another provision. Nowadays, of course, now this 2005, this much of the so-called social media was not there. Now social media is there. Everybody is putting whatever he misses, he likes, and we are getting so much of fake news. So section 54 already prescribed that if anybody spreads fake news, they are liable for punishment for 1 year penalty. This is there in section 54 2005 Act. Of course, section 61, it prohibits discrimination on the grounds of sex, caste, community, descent or religion. This is also now slowly coming up. Anyway, this does not matter much because India is a secular country. We don't discriminate anybody for all these things. Now, when we are coming to know that the armed forces are coming, please remember, you have to remember this act also. Armed forces within bracket Special Powers Act 1958. So they give sweeping powers to the armed forces. Of course, in the case of Naga People's Movement of Human Rights Association of India. So Supreme Court held that they are also bound under the provisions of CRPC. Right? Anyway, these are the important sections, and please remember 41 million migrants, they are now exoding. Exodus literally is taking place from one place to the other. And please remember Article 39 says of the Constitution says that the state should provide adequate means of livelihood. But please remember now why we are all surrendering ourselves, or why we are all literally affecting ourselves to the coronavirus, or to the we are sticking to the homes, is because we know the ill effects of the coronavirus. So this is doctrine of necessity. Therefore, we are all staying here. So friends, remember, these are all the provisions of law under which the government can restrict your movements, can restrict the assembly of persons, can restrict the vehicular traffic, can restrict the movement of any person, and can allow the armed forces. Now I have told you the sections in detail. Please read the Disaster Management Act as well as the Epidemic Diseases Act, and then you will be thorough with the provisions of law. And of course, please remember the emergency provisions, they did not come into force. Thank you.